Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions. Presented by Wassinger Law Office. Join us as we unravel legal complexities and secure your family's legacy.
Hello and welcome. I'm in conversation with lawyer Matt Wassinger with Wassinger Law Office based in Orlando, Florida. The topic is estate planning. Matt, welcome.
Thank you, Nancy. It's great to be here.
Please share with us a little bit more about yourself and your law practice.
Well, I am married with a little 4-year-old daughter who is going on 14 years old. Extremely precocious and bossy, but we like her that way. At least we'll keep her. And I have been running my own firm now for almost 12 years here in Orlando, Wassinger Law Office. We focus on estate planning, their topic today, real estate law, and then it's a true family firm. My wife also is in the firm with me, and she practices entertainment law, more specifically kind of copyright and trademark issues.
What is the purpose of an estate plan?
The general idea is it makes sure that your family knows what you want to happen with your family or your heirs or whomever you've designated things to happen with your assets and your possessions and your general wishes. But an even more important backstop is if you end up in court, it tells a judge exactly what you want to happen with all of that. So it gives everyone a playbook, essentially, of what should happen when the worst happens, which is you pass or in some cases become incapacitated and need someone else taking care of your affairs for you.
What age generally or stage of life should we get started on a estate plan?
Well, we tell everyone basically the second you turn 18, and if you've got kids going to college, you think of them as more of still kids as opposed to adults. But basically, once you turn 18, everyone should have some form of an estate plan, right? Once a kid goes to college, or once they turn 18, they're now in charge of all their financial decisions. And the parents, while they can try to help while they're there, they can't access the finances. They can't access or get medical records on their own without proper documentation. But short of college kids going out and getting their powers of attorney done, anyone that's got some property or some assets that they want to go to a specific place, they absolutely need an estate plan, which is kind of where a disconnect is. People my age and younger specifically think that they don't need an estate plan until they get much older. But the idea is people pass away at any age and any time, so we need to prepare for that as soon as possible if you want any control over what happens with your assets.
What are some of the myths about estate plans?
The one big one is if you have a will, you avoid probate. And probate court is basically a lawsuit that someone opens to find out what you have, what you owe, and a judge makes a decision about where it goes. So people think, oh, I have a will, my family's not going to have to go through probate. That's not the case at all. If you have a will, there's a probate. That's the way it goes. The only way to truly avoid probate is with a trust at that point.
So help us understand all the proper estate plans, what they should include. I mean, it's quite diverse and what's needed.
Yeah. So, the number one thing is everyone, obviously you start with a will. And then from there, you're wanting durable power of attorney, which is a financial power of attorney. You're wanting advanced medical directives. So a medical power of attorney, HIPAA release forms, which allow people to go get medical records from different doctors on your behalf. A living will, which in Florida specifically is not exactly a do not resuscitate, but it puts in, it is a do not resuscitate, but it puts in very specific rules about what that is. So you can let your loved ones know whether you want to be stuck on a ventilator for a long period of time or not, essentially. So those are the very, very basics. And then from there, you always want to include kids protection planning, which our firm offers for any minor children. So permanent guardians named. Our firm also names temporary guardians, gives instructions to guardians, instructions to caregivers. So, and medical power of attorneys for those on behalf of those kids for the ability of those guardians to be able to handle any medical decisions that may come up at that point in time. And then, of course, depending on your goals and your estate or your assets in general, a trust comes on top of that to be able to keep everything out of the court's hands and in your family's hands.
Now, you were talking about children, of course. What happens if those details aren't included and you pass away?
Then a judge is making all those decisions for you. And that doesn't always necessarily go with what decisions that you would have chosen for yourself. And that is why we try, our firm's overall goal is out of court, out of conflict, because when you're going to court, even if you have a will that says, I want this, 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 and this to happen, people can show up, because probate is public, can show up and claim, oh, this person said they wanted this done, or this person said they wanted this done. And you want the playbook there, but if the judge doesn't have to necessarily follow it, because they have to take into account all of the different things that are happening. And in Florida, interestingly enough, if you have no will and you are married and you have children, your spouse is going to split almost everything with those kids, which a lot of people don't know. So if you don't have a will at all and you've got a shared house with your spouse, the spouse has a life estate till they pass away. The remainder goes to the kids. And then there's what Florida was called an elective share, which can get technical, but basically they get a portion of the estate. The rest is saved for the kids. So if you wanted everything to go to your wife and the wife to be able to decide not she gave anything else to the kids, you have to have something in place to make those decisions.
So, I mean, this sounds incredibly detailed, but where do you begin with clients? Like, walk us through your process.
Well, we try to do things differently than 99% of other estate planning firms. And in the way I say that is, most of the time you go to an estate planning attorney and say, they might have some homework for you to fill out, they might not, and say, here's what we have. And they'll give you their opinion of what you should do. And then you'd come back for a second meeting where you'd sign everything. They'd give you some instructions about what you should do in terms of titling your assets or next steps to make sure that your estate plan is followed the way you need to, and they'll send you on your way. And it's very transactional. It's call us if you need us type of thing. But in those cases, 99% of the time, people that come to us with other estate plans done by other firms, none of their assets are titled the way they're supposed to, because the same reason it takes people a long time to get in to do their estate planning, life gets in the way. They get busy. They'll get to it. And if that's the case, you haven't followed the steps after everything's assigned, you end up with an expensive paperweight, essentially, because there's a lot of documents. Some might work. Most of it probably won't. So what we do is we start with our family wealth planning session, which we make you do homework before you come in, which outlines not only your assets and your liabilities, so what you owe, it also asks questions regarding your goals. Because our job in that initial session is to educate you about your options and what would happen to your assets and your kids or your beneficiaries if something happens to you. And we focus on what your goals are, because the goals should determine what your estate plan is more so than just your assets. If there's an attorney saying you need X number of dollars to have a trust, or you don't have you absolutely need a trust, they're not listening. We've got high net worth clients that do not care about probate, and they're saying, I'm gone, my family can deal with it. And we've got people that have very few assets that on paper wouldn't say normally would need a trust, but they don't want their family to go through that process. And because probate's very expensive, about 4.5%, give or take, of your gross worth, doing a trust now saves their family 12 to 18 months, give or take, in a probate court, with 4.5% of the gross worth taken out and their assets locked up. So we focus specifically on educating in that family wealth planning session once we get the homework in, and let them kind of choose their plan. And that's the best way to get started, because at the end of that family wealth planning session, if at the end of the day we decide there isn't a good fit between us, or you decide you want to go in a different direction, you've left a little bit more organized, and you've left a little bit better educated about the estate planning process and what your options are at that point.
What about some tips for listeners on how to get started? Well,
the first thing is you just got to get a meeting booked, because in our system, once you book a meeting, you'll immediately get an email with the intake form, and it will start asking you those questions, asking for that information. So when you come in, we can outline all of that. Our system, we try to make things as painless as possible. So while there's homework and information you're going to have to get us, we're going to move you along on the way. That'll be the first of 3 meetings. We'll then bring you back for a signing meeting, but that signing meeting, we're only going to give you what you need to go get your assets transferred or titled in a way that fits your estate plan. And then we'll bring you back. We won't bring you back for the 3rd meeting until you get all that done. We want our estate plans to work. So once you get started with us and sign up with us, we keep you moving and we'll stay on top of you. You can ask our clients. We follow up. You get lots of reminders. You get lots of emails saying, hey, we're still waiting on this. We're looking on this. Where are we at on this? Because we want our plans to work. So we make sure that we keep you moving in the right direction to get it all done.
When we spoke earlier, you had mentioned that there should be caution, and we touched on it a little bit about perhaps like shopping for the lowest price. What's the caution there?
The caution is having a plan that doesn't work when you need it to. And that doesn't help anybody, because where you end up is right back in court, right back in probate. And the problem with not knowing what you're getting or what you're putting into a plan means that there's going to be holes in it. Do you have backups for backups? Do you have successor trustees? Do you have a backup personal representative? Do you have, when you name your guardians, are you naming them what happens if there's a couple and they get divorced? Are you naming the wife? It can only continue as the guardian, or they have to go to someone else. Those extra steps that DIY documents or the very cheap planners out there are giving you, basically a one-size-fits-all plan and fill in forms, and then you're stuck with something that may not work.
The detail you had mentioned when going back to children, you had when we were speaking, you had mentioned too that if you have a special clause or a special area where if something happens to the parents, you have that immediate guardian, as opposed to what can happen if you don't have that.
Right. So the temporary guardianship. So what we do is we give the normal nomination of permanent guardians, which are the people that would take your minor children and raise them on your behalf if something happens to you. But sometimes those permanent guardians may not live in the city that you live in, or may just be out of town on vacation. And it takes them some time to get there to take care of the kids. The problem with that is if it's the police or hospitals, they're not allowed to just give the kids to anybody that comes. They're required to call Child Protective Services, because that's who needs to be in charge of the kids until someone is legally able to take them. So what we've done is we've added a temporary guardian legal document that says these people, and sometimes they're neighbors, sometimes they're just close friends, but people that are usually close by, that the children know that they can go stay with until the permanent guardians are able to show up and take them from there. Because if this situation happens, your kids are going to have enough on their plate. They don't need to go sit at Child Protective Services or stay at a police station until somebody that they know is going to be able to take care of them can come.
Why do you think people put it off so much?
Because no one likes to think about this stuff. It's not fun to talk about it. I mean, it's death and taxes. No one likes either one of those things, right? That's what we're trying to avoid. But, what I always say is I can't tell you when something will happen, when you'll pass, when you die, but we do know it will happen. And the only way to make sure that your family is out of court, out of conflict, and you have everything put in place so they can move forward with as minimal emotional and financial drain after something happens, is by getting started and getting something in place.
And it starts with a phone call.
Starts with a phone call. Or, if you're not big on the phone, website, you can schedule everything right on there, online.
So once everything is in place, is it sort of like it's done and you kind of set it and forget about it, or does it need to be revisited?
No, that's actually one of the things we tell our clients when they come in. This is absolutely not a set it and forget it type of thing. So one of the ways we make sure that people keep coming back is we offer a free 3-year review with every estate plan, because in those 3 years most of the time, and it can be sooner if there's a major life change. We have people come in, obviously, but life changes, your assets change, or sometimes your goals change, but almost always the law changes a little bit too. So we need to keep track of all those things to make sure that your estate plan is staying up to date so it works when you need it. That's why our plans work, because we're going to bring you back. We focus on being a family attorney, meaning we're here for you when you need it, not a transactional attorney, which is just come in if you need something. Call us. We're here to help. That's the goal. And that's what we try to continue on with the 3-year reviews.
And what is the best way for listeners to connect with you?
The website is easiest all around. We've got all sorts of information for them to be able to review. They can also read our blogs that we post at least once a week. And there are links for our webinars, which cover our kids protection plan in more depth and just general estate planning as well. But you can schedule a meeting right there on our website, have the phone number there to call us at any point in time. And, if you don't want to go straight to WassingerLawOffice.com, you can just Google Wassinger Law Office and our Google business page will show up and you can one-click call from there.
Great. Matt, thank you.
Thank you.
Matt Wassinger is an estate planning attorney with Wassinger Law Office based in Orlando, Florida. Please remember to like and subscribe.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.